this might be a good segue into because I need explanations on this. Children's Defense Fund is suing the FDA. I don't know who else is in the lawsuit. And the basis of the lawsuit is that, I'm going to use the word of the lawsuit, a bait and switch, in that the FDA approved the Pfizer vaccine, apparently giving it full authorization. But what is authorized is, in fact, this is where I have trouble understanding what's going on, is no different than the emergency authorization use vaccine. And they've sort of what is being called a bait and switch, in that purporting to have gotten full FDA approval for what they are administering, which is not fully FDA, but is still under the EAU, but it's the same vaccine. So explain this away, because I don't understand the distinction between the vaccine itself, and I think I can understand some of the legal reasons why they want this, but explain exactly what's going on, and I'll try to step in if I don't understand the explanation.
Sure. So, I mean, the conundrum they faced is that if they gave a biologic license, and that's what FDA approval means in this context, if they gave a biologic license to any of the COVID-19 vaccines, then they had to revoke the emergency use authorization for all other vaccines. Because once there is any biologic license for any COVID-19 vaccine, then you can't do emergency use authorization for any other vaccine. And they wanted to get around that. So what they did, but on the flip side, the military and many other people, apparently including this mandate by Biden, is to get the FDA approved biologic licensed vaccine. But the problem is for them was that means they would have to revoke the emergency use authorization for all the others, including for Moderna's and J&J's. And instead, what they did is they said, yes, we're giving a biologic license to this COVID-19 vaccine. However, it's not available yet. And consequently, we're going to continue with the emergency use authorized ones that are legally distinct, but medically interchangeable in the FDA's language. And so now whether it actually is medically interchangeable is subject to debate. The thing is that when it's a fully biologic licensed product, it has to meet certain manufacturing standards, certain distribution standards, and certain marketing standards that are different than what an emergency use authorized vaccine that has to meet. So from some scientists' perspective, they're not medically interchangeable. But at a minimum, they're definitely not legally interchangeable, because it is clear that an emergency use authorized vaccine is completely immune. Everybody connected to it cannot be sued. Whereas it's not clear, it's a subject of debate, whether or not the FDA biologic licensed vaccine shares that same degree of legal immunity.
Okay, so and back it up just for one step. Let's just say there's four EAU or EUA emergency
EUA.
EUA.
Yep, it's like the European Union with an A added on it. That's how I remember.
Okay, so I got it. Never going to forget now. EUA. You got Moderna, Pfizer, Johnson & Johnson, whatever. So if any one of them, they're different. Some of them are mRNAs. One of them is an actual vaccine. If any of those that are out there now that are EUA approved, if any one of them gets full FDA approval, then the other three lose their EUA, because now you have an approved vaccine, which would then become the standard for the vaccine, and the other ones would lose their emergency use authorization, because you have an available FDA approved vaccine, correct?
Exactly. That's what the law requires. That's the federal law.
And so now the argument here is that they've approved one, and I think it was Pfizer, correct?
Yes. So they approved the Pfizer one under a different name, the name it's used in Australia and some other places where it's been approved. But they are pretending it's not available. So they are not widely available.
So they say, we have one approved, but it's not widely available. So we're going to retain.
But it's really kind of the same thing as this other thing. So, I
know. No, but in fact, as far as you know, Robert, no medical advice, no nothing. Is it the exact same thing? Is there any practice?
It depends on who you talk to. Some people would say there's significant differences. Others would say there are minor, insignificant differences. The FDA has said they're minor, insignificant differences.
And I guess it actually doesn't make a difference. Let's even assume that there are significant differences. They say we got FDA approval for the Pfizer. We'll call it the Pfizer 2.0. But it's not widely available, so we want to retain the emergency use authorization on all the other vaccines, which we will continue to administer. but now people are potentially under the impression that what is being administered, although in fact an EUA, has gotten and not in fact gotten FDA approval.
That's exactly right. And so for like the military, they're only being required to take the FDA approved one. What the soldiers are not being told is that's not the one they're being given. The FDA is advertising on Facebook and other places that the FDA approved one is available to them locally. That's false. So the different marketing, different manufacturing, and most importantly, different potentially legally. So people may believe, okay, I'm getting one that I can sue somebody if something's wrong. It's up in the air. It's not clear whether you can or not, but there's at least a chance of it. Whereas there's no chance of it if it's an emergency use authorized one. I mean, right now they're continuing to medically experiment on people. That's what the emergency use investigational drug is called, while pretending that they're not. And that's where our objection was, look, Judge, they got to, crap or get off the pot. They got to either say, yes, make this available, or admit it's not available and quit lying to people. And we requested a temporary restraining order. The judge said he wants to wait to hear from the FDA first before he grants any restraining order. So we'll see how that goes. So that'll be a couple of weeks away.
That is the lawsuit. I don't think we need a detailed breakdown because it's a short lawsuit, which I like.
Oh, yeah. It's right to the point.
12 pages.
Yeah. My question to the judge is: are we going to hold people responsible for lying to the country or not? Is the judiciary going to step up to the plate or hide?
This is the question I had: is that even if we operate on the basis of the Pfizer approval, there's still Moderna, there's still Johnson and Johnson, and people. I guess the argument is, or the fact is, that people are under the impression that if you get the Moderna or the Johnson & Johnson, it's received FDA approval as well, which, as a matter of fact, even if we set aside the Pfizer distinction, it has not?
Correct. It is not. And here's the game they're probably playing. They're probably trying to wait to make the Pfizer FDA biologic licensed one only available after they put it on the children's list. Because once they put it on the kids' mandatory immunization list, then it has full immunity. What is there's this legal questionable land they're in right now. If they put out that one under that label, the FDA approved one, maybe they can get sued if they've made a mistake. Whereas if that's why I think they want to keep the EUA one in for as long as possible until they can stick the Pfizer one on the child's list so that it has definite immunity from suit. And it's kind of strange, this very safe and effective drug that everybody's worried about nobody being able to sue over.
Is there an issue that they want to deplete the inventory of the EUA before going to a fully approved FDA? Like, is that
that's a partial explanation, but it's not part of the legal excuse for the word available. Especially if they're going to claim it's truly medically interchangeable. If it's truly interchangeable, then we're just debating a label. We're back into low papa Hiram, high papa lowrim.
Well, that's what I understood now. But even if we then say that there's minor differences, or even if we accept that there's major differences, that would actually be a bigger issue. If there are in fact major differences between the FDA approved and the EUA, and people are being represented to that what they're receiving now got FDA approval, but it's the EUA inventory, which has major differences from the one that just got FDA approved, they're under a factual and relatively serious misunderstanding. And I must say myself, I was under the impression that it was not just Pfizer, but that all of the vaccines that were being administered had in fact gotten FDA approval.
Because that's how they misled people. It was a massive deception campaign.
Okay, and then the legal ramifications for anybody who's wondering. I mean, we know now that everyone under the EUA umbrella, full immunity, left, right, and center, maybe up to the exception of employers who compel it for adverse effects. Under the vaccines, there's not immunity, but there's a fund that limits liability for the manufacturers. So you can't go sue them for $1 billion, but you can go make a claim with the vaccine fund for any damages, and therefore you could, in theory, be made not whole ever. And
that particular vaccine fund is almost never paid out. They have a whole different set of standards of causation than they do for COVID and other things. The standards radically shift when you try to make a demand for what is relatively small amounts of money. I think the cap is $250,000. So if you have lifetime medical problems, you're not going to get anywhere close to compensating it.
All right, that's very cool. So the motion itself, has been presented to a judge. Now, what stage of the file is it at? If we could, if we're
So,
allowed to ask.
yeah, so we had sued and served them and filed an ex parte motion to try to get what's the equivalent of a temporary restraining order. We're filing a petition to stay under the APA, so it's a separate, but it has the same analogous standards as temporary restraining orders and preliminary injunctions. The court issued a ruling saying that he was going to deny the TRO because he wanted to wait to see what the FDA had to say. And he wasn't sure that what the injury was yet. So we're going to be filing lots of declarations of a bunch of soldiers and other people to explain what the injury is. The injury is that they are at imminent risk of dishonorable discharge or being forced to take a drug that's different than the one they're being told it is. And it's really about how much are the courts going to defer to the executive branch in times of emergency, perceived emergency. I mean, the fact that we have now a 2-year emergency going should have been a warning sign to everybody.
That's one of my political talking points. If you can't pass a law after 19 months of an emergency, the government is the problem and not the emergency people.
Exactly. And that's, and the same thing here with this mandate. I mean, if Biden believed in it, why didn't he go through Congress? Make it clear. Have Congress give the authority directly to OSHA to be able to mandate vaccines. He knows it wouldn't pass. And so it shows you our fundamental tripartite system of government has failed for the last 2 years. And that's the legislative branch being ignored and the judiciary branch playing coward. And the only question is whether the judiciary branch is going to earn their paycheck or not.
David Individual says, Robert, can I presume he meant sue my county to try and block county employee mandates if I'm not a county employee? I guess that's locus standing.
It depends. Yeah, that's a standing question. I don't like standing, so I would consider that an injury question. It would be a legitimate injury question. How are you individually injured by it? So generally, you need to be someone with a threatened injury to be able to sue in general. But it's called standing in the courts. Standing is so badly abused that I don't like it. But injury has always been part of the law.
I'm going to read Lisa Schuplein from Rumble Rant says, are there penalties for lying about the approved vax being the one being given today?
Well, that's my argument, is that there should be, and the penalty should be that the FDA should be prevented from saying that there is a approved available vaccine when it isn't available according to their own terms, or they should revoke the emergency use authorization for the other vaccines. So they should do one of the two. To be able to get away with deception is dishonorable of our entire public health apparatus. And the question is whether the judiciary is willing to step into the breach. So that should be the consequence, but otherwise there's none. It's the problem when only the government can deal with the government. I mean, for example, to sue directly under any of these immunity provisions, the government has to join the suit to say it's a willful misconduct. Well, they've never joined one ever in history. So, I mean, asking the government to take care of the government has never worked.
And no, it's an amazing thing because I think probably if you ask anybody, they're under the impression that whatever they're getting now is FDA approved, and it's one of three things. It's either it is in fact what was approved is identical, no problem, at least for the one vaccine. Either it's somewhat different, in which case the differences might be not major, so it might be interchangeable, or the differences are major. And in which case, they're basically depleting the already built-up inventory of the EUA vaccine, which is materially different than the one that was approved, and warranting that everyone's getting it. It's overnight magic now. All that inventory just got the blessing of FDA approval when that's not the case. So that's an amazing distinction, and the pieces of the puzzle, in my mind, of understanding just fell together. So I hope everyone else now fully appreciates that. That's very interesting. Is there a timeline on the lawsuits? Like, do you have a schedule?
I mean, I'm hoping the court will schedule now on the stay motion itself, an expedited hearing and briefing schedule to have, so that a hearing is held within at least 2 to 3 weeks. But it's up to the court. I mean, and if the court goes slow, then we'll look at other suits that we're going to be looking at bringing anyway. And I think once the feds really push something through, an actual rule, which is supposed to be forthcoming within a week or two, then there's going to be a lot of litigation there. So the courts can't hide forever on this. And
Michael R. says, what about remote workers? How would a vaccine mandate affect the company if I work remotely? I mean, I read a story about a remote student was required to take a vaccine or show proof of vaccination in order to access online classes. Couldn't verify the details myself, but it sounded preposterous. But
Well, I've received emails from workers who are in that exact position. It's insanity. It's just insanity.
Okay. Now, what does this one fit into? So that's the Children's Defense Fund lawsuit.
Or Children's Health Defense, yeah.
Children's Health Defense. Sorry, Children's Health Defense.
Yep.
Sorry, and ultimately, what are the sanctions that you're looking for in the lawsuit? I mean, it's
we're asking is to stay the FDA's approval of the biologic license, unless and until they revoke the emergency use authorization for the others. So that just put them to their test. They couldn't approve it if it wasn't available, and if it is available, then revoke the EUAs. But quit lying to the American people.